The nation's highest court denied BP's request to continue to block millions of dollars in claim payments to businesses while it wants to see if the high court will in fact hear arguments in the case. Now, the request from BP was in the spotlight, as you all know, after it was learned that Justice Antonin Scalia could decide on his own whether to impose the stay. Now, Scalia's son, he's a partner at the law firm representing BP, as well as the son of Supreme Court Sam Alito, who's also in the same firm. Now, we've seen conflict of interest cases in the past involving judges hundreds of times, not just on the high court, but in different courts and all different levels across this country. Recently, it was discovered that more than a dozen federal appeals court judges have violated federal conflict of interest laws over the past 3 years. You go back to 2001. Judge James Hill of the 11th U.S. Circuit Court of Appeals in Atlanta. He was part of a 3-judge panel that affirmed a lower court verdict in favor of healthcare giant Johnson & Johnson, a lawsuit over a malfunctioning medication pump. And one of these guys even had the case. Hill, it turned out, owned as much as $100,000 of stock in Johnson & Johnson at the time he was making that decision. And the family of a Florida farmer sued DuPont over a chemical he applied to his fields before dying from cancer. The judge ruled against them, and it was learned later that, in fact, he too was a DuPont stock owner. Okay, so I want to bring our panel right now to talk about where that line is or isn't. We got Jimmy Kasouras, criminal defense attorney in Manhattan, lecturing at New York Law School and a visiting professor at the University of Birmingham in England. Doug Von Oist, founding partner of Carsten Von Oist, focusing on corporate misconduct and selected by the Legal 500 as one of the most influential trial lawyers in the country. Bill Aronwald, criminal defense attorney, former prosecutor at Aronwald and Pickett, and Mayo Bartlett, attorney and former chief of the Bias Crimes Unit at the Westchester County DA's office. All right, guys, does this happen a lot more than we think, or is it that, hey, if you had to make every judge recuse him or herself for every possible connection to a case, we'd have a hard time getting cases heard because of the 6 degrees of separation? Which one is it?
Well, there is a procedure or mechanism where a lawyer can ask a judge to recuse himself or herself based upon a potential conflict of interest. Now, Judicial Code of Ethics basically says that a judge should recuse himself where there is an actual conflict or where there could be an appearance of impropriety, such as the public's confidence in the system would be undermined. The problem is that when you're dealing with Supreme Court judges, and let's say you make an application for a judge to recuse himself and the judge refuses to, who do you appeal to?
Well, they don't even go to the Supreme Court, Bill. As I understand it, judges are like a fraternity, right? And that there is a downside. If you go to a judge, basically recuse yourself if you haven't done so already, because I'm questioning your objectivity. He or she, now you're on their downside. And then whoever's going to take the case isn't exactly going to probably be your biggest supporter. That has to go into the mind of an attorney.
Here's the way I think it's done in the real world, okay? Judges get embarrassed when you make an application, which is a publicly filed document, saying, I don't think you could be fair. I think you're biased. So the way I think to do it, to approach it, is you raise the issue with the judge off the record, letting the judge know that you sort of feel compelled to file the motion, but you'd like to avoid it if possible, and you give the judge the opportunity to recuse himself on his own application. Where the judge doesn't do that, then the lawyer's got to make the difficult decision. Because if the judge isn't going to recuse himself when you approach it informally and you do it formally, now the judge, there's a document which you're saying you don't think the judge could be fair. And there is a circle the wagon, approach judges, among lawyers too.
Yep.
So Judge X, disqualifies himself or recuses himself. Now the case goes to Judge Y, and it just doesn't work.
Man, you ever have a case, and I'm not asking you to name the judge or the case, where you said to yourself, wait a second, I know a little something here, I'm getting a vibe that, this ain't a level playing field here. Did you find yourself in that box ever?
Oh, absolutely. I've had circumstances where I've been on trial and I've even had applications and the judge off the record makes a statement that, if the boss is in the DA's office, If my application is successful, the case will be dismissed and jeopardy will attach, and the DA's office will not be pleased with that. And it's really not their job to be concerned with what either party will be pleased with. But I also have had a lot of opportunities to observe judges come forward and tell us that they have a potential conflict, or that it could be something as simple as, I belong to the same fraternity as the defense counsel, or perhaps as a party to the case. Do you think that it's if I'm just disclosing it? And that's how it should happen. The judge ought to come forward and disclose any potential conflicts, because, as Bill said, it's the appearance of impropriety. It's the highest standard, really, that you're going to have. The big issue is when the judge is aware of a conflict that we very often may not even know exists. We have no idea that this person is somehow related to the judge's different last name. You have no reason to guess that the judge would be swayed by that. The judge has, as we talked about earlier, an interest in the prison. They're going to get a kickback from the prison. They don't
saw
tell you
that in
that.
Pennsylvania.
Well,
and
that's a crime.
Yeah.
I'll make you laugh. In 2008, I represented one of the bosses of one of the 5 crime families, and we were getting ready for trial. And 2-3 weeks after I came onto the case, my client was accused of constructing a hit list and sending it out with the judge's name on it. I thought it was a no-brainer. So I moved to recuse the judge. I said, I don't know.
Yeah.
The public's confidence in a system where the client is accused of threatening to kill you, I think you should get off the case. Denied my motion, looked at me as though I had 3 heads. The Second Circuit affirmed, and the Supreme Court denied cert. It's hard to do that, and going to your point, litigants should not be put in that position. Judges should come forward, they should disclose a conflict, and there should be, I think, some more hard and fast rules. When you
Because
have
it does seem a little open-ended, Doug. Like, as Bill detailed it, it's kind of a discretionary call to a degree. Use the example I did off the top. If you have not 1, 2 justices who have sons that work at a law firm that are representing, in effect, the plaintiff in the case, in your eyes, is that a disqualifier?
Well, I think the bigger question is, you're looking at these judges to exercise judgment. And if a judge believes that there's a problem, he's usually the one that will come forward and say, hey, listen, I have sons. I know this decision is going to be unpopular with one of the sides. I'm not going to, sit on this panel. That's the strange thing when you hear something like this. Judges are usually very good about telling the conflicts they have. They don't want problems.
But the ones that have the God complex, right? They're the ones that think they're beyond reproach. But
there should be a rule.
I mean, Clarence Thomas's wife, very active, at the Heritage Foundation. They're involved in some of these cases and trying, on a policy front. That's not even a consideration. I understand it's tough, and where do you draw the line, I mean, if somebody has some third cousin that they haven't spoken to in 40 years, why should it make a difference? But if it's your son?
But if you're invested,
Yeah.
as one of these judges, had up to $1 million invested, what was it, in Vanguard,
Yeah.
there should be a hard and fast rule. If you've got skin in the game, you've got to get off the case.
Well, yeah, but see, that's the skin in the game. I mean, let's take the case that you're talking about. The fact that these 2 Supreme Court justices have sons that work for the law firm representing BP doesn't necessarily mean that they've got skin in the game. They can
I agree
basically,
with you.
okay, and that's why.
You could argue they do, though.
No, you could argue it, but you see,
Yeah.
the rule generally is if you want to appeal a judge's decision where
Yeah.
he denies your motion, recuse himself, the general rule is that it's discretionary on the court, and the appellate court rarely will, unless there's a clear abuse of discretion. Here's the point. The point is the operative words here are appearance of impropriety. Even though these 2 judges may not have any skin in the game because their children work for the firm representing BP, in terms of the public's perception, it has an appearance of impropriety because the normal reaction is, you must have a skin in the game. You should recuse yourself. So it's more the appearance of impropriety than any actual conflict.
We're going to take a break. When we come back, GM says it will not fire anybody else here over those faulty ignition switches linked to 13 deaths. In the meantime, it's been given the green light to consolidate all of the lawsuits. Question, and I think I know the answer to the table, is does big business get off too easy in the American judicial system? We'll be right back with that after this.